right, welcome everyone to the 36th session of the Panitch Training Academy. Today we're going to be talking about intellectual property arbitrations in the United States, the good, the bad, and the ugly. Today's session is being recorded. If you wish to ask questions as we go along, you can use either the chat feature or the Q&A feature, and we'll be keeping an eye on that. And for those of you interested in continuing legal education credit in Delaware, Georgia, Pennsylvania, or Virginia, 3 things to be aware of. Make sure you stay on for this whole session. Be sure to answer the 2 pop-up questions that will occur throughout the session. And at the end of the session, please be sure to complete the feedback survey. So with that, we'll go ahead and get started. I am Erin Dunston. I'm a partner here at Panitch Schwarze. I work primarily in the life sciences, and I do both litigation and prosecution.
Hello, everyone. My name is Ikenna Ejimonyeugwo. I'm an associate attorney here at the firm. My practice focuses on intellectual property, litigation, and patent prosecution. I am part of the life sciences group as well. And I typically handle matters involving complex IP agreements. So arbitration is a big part of the conversation here in our work.
And I'm Phil Hirschhorn, the senior member of this group and a litigator for several decades at least. And so my involvement has included many arbitrations along the way, as well as the district court proceedings and other trial activities like in the ITC. And we shall now proceed.
And before we proceed, I forgot to mention that tomorrow, today's session will be available on the Panitch website, as will the slides. So today we're going to talk about 5 major things, pretty much give the background of arbitrations in the US for IP disputes, talk about the issues that can be arbitrated, the scope of issues that can be addressed. We'll walk through the life cycle of an arbitration, and then we'll talk about what we consider the good, the bad, and the ugly, various aspects of arbitrating in the US, and then provide some key takeaways.
All right, so let's start with what exactly is arbitration. So at its core, arbitration is a private process where a neutral decision maker or panel hears evidence and issues what we call a binding award. Arbitration is one of the most common forms of alternative dispute resolutions. It's designed to be faster, more cost-effective, and more confidential than litigation. So one big advantage of arbitration is that the parties can help select their arbitrator. This allows them to choose someone with technical or legal expertise that's relevant to IP issues. This is important because instead of being assigned a random judge or jury who's lacking on the technical background of your case, the parties can actually choose an arbitrator panel that does understand the technology. And that really can make the difference between an efficient and a frustrating process. So again, just picking the arbitrators with the right expertise can make a huge difference in how efficiently and accurately your dispute can be resolved. And now that we've covered what arbitration is, let's just look at the laws that make it all possible. And that starts with the Federal Arbitration Act, or the FAA. Congress enacted the FAA back in 1925. This was to promote private dispute resolution outside of the courts. So the act provides the statutory framework for enforcing arbitration agreements and ensuring that arbitral awards are recognized by courts. So in simple terms, the FAA says that if you've agreed to arbitrate a dispute, that agreement is binding and enforceable, and that applies in both federal and state courts. So as you see here, the Supreme Court confirmed this principle in Southland Corporation versus Keating, and they held that an arbitration clause as enforceable in federal courts is equally enforceable in state court as well. So the FAA just doesn't encourage arbitration. It requires courts to respect agreements, and that reflects a strong national policy that favors arbitration, which we'll touch base on here throughout these slides.
And when we talk about the Federal Arbitration Act, we're also talking about giving life and meaning to clauses that are put into contracts between parties and private parties at that are going to govern these disputes. And that let's start at that beginning idea that somebody somewhere in the drafting process of an agreement between two parties has to have a clause in the agreement that says we're going to go to arbitration, or the parties are going to have to agree to go to arbitration and effectively enter into a contract that says we agree to go to arbitration. And we'll talk more about that clause in a moment. But so the FAA provides what we call the statutory framework for arbitration in the federal courts and what the federal courts will do when they get arbitration cases given to them in one way or another. With respect to agreements to arbitrate, those will be given basically full force at all points in time, unless there's some real reason to believe it shouldn't be given. And that's going to be very hard to, as we talk later, dealing with appeals will be very, very hard to overturn one. It authorizes courts to stay ongoing litigation or to move things to stay and then move them to the arbitral forum, whatever arbitral forum that may be. Section 5 concerns the appointments of arbitrators and kind of what you need to make sure you have in there. There has to be some duty of honesty, candor, good faith, things like that. And then sections 9 to 10 govern the arbitral award itself, how it will be confirmed in the court if necessary, whether there's any opportunity for vacatur of the award, some modification, some correction, those sorts of things. Next slide. And, the Federal Arbitration Act in the end represents Congress's really strong federal policy favoring arbitration. And that makes sense. Even at the time that it was enacted in 1925, there was a feeling that there were a lot of disputes that really could have a better and quicker outcome outside of the federal courts. That only became more and more noticeable as discovery expanded and we got into the 80s and the 90s where discovery is electronic and millions of documents as opposed to just tens. And so now there's a way to try and truncate these proceedings in some way. And so that's really what this slide is about. That's slide 6.
All right, on slide 7, we talk about some of the key roles of arbitration in an IP case. A key distinction between, for example, district court and arbitration is that the proceeding is confidential. Of course, in district court, there are ways to try and keep things confidential. You can file under seal, etc. But there's always a bit of a risk due to public policy really favoring in the district courts every part of the procedure being public. In an arbitration, you can shield trade secrets, proprietary technology, sensitive commercial information. Basically, it's behind closed doors, and that can really be a key point for a potential litigant, and one of the things that really does make arbitration stand out. That can be at times a double-edged sword, and we'll get to that when we talk about the good, bad, and ugly. But overall, the confidentiality associated with arbitration is seen as a real benefit. As Ikenna mentioned earlier, whether you choose one arbitrator or a panel, you can do your best to select one with attributes that suit your particular case. You might really favor one that has legal expertise or technological expertise, or you might be able to find one with both. So again, this can be a key distinction because even in courts in the US that are patent savvy, the fact finder may or may not have that technical expertise. And certainly juries are typically lay people not necessarily having the legal expertise. So when it gets down to really nuanced issues, as is often the case in IP disputes, the attributes of the fact finder can be quite important and a bit different from district court. Also, arbitrations are supposed to be streamlined. The parties can work together to talk about the scope of discovery, but it could end up being quite limited. Also, the scheduling is relatively flexible. So overall, there can be tremendous efficiency with an arbitration proceeding relative to a district court. Also, there should be no neutrality. So that can be especially valuable for cross-border IP disputes. You might be able to avoid a little bit of the home cooking that you might get in other venues. And another aspect of arbitration that stands out is the awards are enforceable under the New York Convention that dates back to 1958 and was ratified by 170 countries, so you can get cross-border enforcement in arbitration matters.
All right, so how does arbitration specifically work in the patent context? So Congress addressed that directly in 35 USC section 294, which allows parties to voluntarily arbitrate patent disputes. And that includes issues like validity, infringement, or rights under a patent. And really that can be set up in two main ways. So it can be set up in advance through an arbitration clause in a contract that involves patent rights, for example, in a license or joint development agreement, or it can arise after the dispute occurs, if both sides agree in writing to submit the issue to arbitration. So once that arbitration agreement is made, it's binding, irrevocable, and enforceable, typically just like most other contracts, unless there's a valid reason to revoke it, like fraud or duress, and we'll touch base on those reasons in just a bit as well. So what's really important here is that Section 294, it formalizes the use of arbitration in patent disputes, giving parties a way to resolve complex IP issues privately and efficiently, while preserving the public's right to challenge a patent separately before the USPTO. So now that we've seen, how arbitration fits into the patent framework, let's talk about the scope. And this will include kinds of IP disputes and what actually can be arbitrated. So in practice, IP arbitration most often comes up in disputes, again, involving patent infringement, validity, ownership, breach of licensing, or technology transfer agreements. These are just some examples of situations where parties have a contractual relationship already, and it'll make sense to resolve the disagreement privately through arbitration instead of litigation. But arbitration isn't just limited to patents. As you see here, trademark and copyright disputes can also be arbitrated. So the main point here is that, arbitration is a flexible forum, whether you're dealing with a patent license, software copyright, or brand dispute. Arbitration can handle all of them as long as the parties agree to it. And that takes us to the next slide, the parties' consent and jurisdictional basis in IP arbitration. So in arbitration, unlike court litigation, it's based entirely on agreement. Really, there can be no arbitration without consent. Consent that can come again in two ways. First, it's built into a contract. That could be, an NDA, joint development contract, that says the dispute will be resolved through arbitration. Even if there isn't a clause in place, the parties can still agree afterwards. So once the parties agree, the arbitration provision becomes a jurisdictional foundation for the case. It can define how and where disputes will be resolved, what rules apply, and sometimes even how the arbitrators are chosen. So again, the takeaway here is that the entire arbitration process starts and ends with the parties' agreement. So with that mutual consent, without it, there's no authority for the tribunal to act.
Okay. Let's talk a little bit about arbitration clauses. And I mentioned this earlier. Ikenna just kind of got to some of the points related to these. Again, this gets back to a lot of times when these negotiations are occurring, it's the last thing you think of. And you're not really focusing on the disputes because you're all happy. Everybody wants to get to a yes, get a great agreement together, go on their merry way, share patent technologies, develop great commercial products. But the reality is that we see many agreements running into problems. Sometimes it's at the edges that can easily be negotiated between managements. Sometimes it's not and requires intervention by a neutral. whether that's the district court or, in the case of a situation where you have an arbitration clause, an arbitrator or arbitrators if you've chosen a panel. So what can you do in your arbitration clause? Well, you can really do anything you want. It is a contract. You can say exactly what it is you want that arbitration to look like. You will talk about, for example, the scope of the dispute. And I say this, and I think if you go to the AAA website, there are forms of arbitration clauses and how to refer things to the AAA, how to refer complex commercial matters to the AAA. The same thing in JAMS, which are other arbitration forums. They all have form clauses that you can use, but you can build into those and make them any way you want. So, for example, we've got the any dispute arising out of or relating to this agreement, which is fairly broad language. And we've had cases that have gone to the district court where parties have decided, well, I want to go in the district court, so I'm going to have some odd tort claims that don't really seem to arise out of or relate to the agreement. And it's really going to be up to you and the courts to work together to try and make an understanding about what the clause does mean, how it is that the disputes that are being raised in the district court should be compelled back into arbitration. So that's part of the scope of the dispute. You can talk about whether you're going to have patent validity or trademark issues or copyright issues or just any issues, all going to arbitration, aside from things like royalties and other management issues under the agreement itself. You can have a choice of law and forum, and it's key to try and think about what you want. Do you have two transnationals who are looking for a neutral forum? Do you have an international client who is together with a domestic client, and the domestic client wants it in their forum? Well, maybe that's not a good place to be. Maybe you want to be in a neutral forum. So you want to think of those things in advance. You want to talk about confidentiality and how to protect it, that there will be confidentiality not only in the agreement itself, which is typical, but also in all proceedings related to the arbitration. You'll explain and can really get into the parameters of discovery, how broad, how narrow, how many depositions, things like that. And you can talk about the damages and the remedies in some way, shape, or form. Will you have the ability of the panel or the arbitrator to put in place injunctive relief or other specific performance, not just money damages? Next slide. So, and the awards could be non-binding. The reality is that the binding arbitration is the much more common one. A non-binding arbitration is it's going to be much slimmer, and it's really going to be directed at single issues rather than multiple issues. So I think we typically talk about binding. Now, I guess I have, this is my slide too, I forgot. Public policy considerations in arbitration. Like we already said, a court will generally enforce arbitration agreements. It has to be a violation of public policy not to, and that's very, very, very rare. Then federal policy endorses arbitrability, as we've already said, and those same considerations, like in Kamikaze Music, apply to IP arbitrations. There is a question pending about clauses. Hold on, I'm going to pull it up so I can see it. So it's, do you advise including in the arbitration agreement language precluding administrative challenges to patent validity? The answer is yes. I would phrase it basically saying, and I agree, Rick, with the thought that the board doesn't think that they are necessarily bound by private contract. And I saw that and I was reading that case just the other day for some reason. I don't know why. But the reality is you can do it. Whether it's enforceable fully is going to be a different question. But I think if you have the arbitration agreement together with having no other ability to go out, I think that's the way you would do it. You may end up in a court dispute. And I agree that that is going to be a challenge. Can you go to the next slide? Oh, and before we go to the next slide, poll number 1 is up for CLE credit. For those of you seeking Pennsylvania, Delaware, Georgia, and Virginia CLE, please answer yes to the below question. Otherwise, do whatever you want. You've all had an opportunity. I think you're all fast enough. Let's go to the next slide. So we should be in slide 14. This is really just a continuation of the idea of public policy and the considerations in IB arbitration. Oh, I have to do something with this. It's on my screen. Get out of there. But basically, again, Bayer Crop Science is a similar case. It violates constitutional patent policy against double patenting. Well, that's not good enough. You can't just say, hey, it violates the law and therefore we didn't like the award. Well, that's a challenge around. They're going to say, nope, that's not good enough. That is not one of the real factors we're going to look at to overturn a decision. Next slide.
All right. So what happens in an arbitration? What happens when? We're going to walk through a little bit about how it gets started, the filing of the key documents and basically initiating the arbitration. Then we're going to discuss arbitrator selection. Then we're going to move on to the preliminary hearing, information exchange and preparation, the hearing itself, post-hearing submissions, and the award. And that altogether is kind of the skeleton or framework for a typical arbitration.
Okay. I think this is my slide, and I'm going to talk about initiating arbitration and the choice of a provider. So this, in large measure, there are two possible routes here. Number one is you have specified in your arbitration clause that you are, for example, going to one of the lovely entities below. And one of those lovely entities is the AAA JAMS. I've been in front of both of those, WIPO, the International Chamber of Commerce, doing arbitration more in the international realm, and providers like that. You could also choose which one you want to go to if the parties decide that they don't want, for some reason, to go to the AAA, and they've had it in their clause. They can say, agree not to do AAA, do somebody else. So one of the things you want to make sure you do is, as a first measure before you file, if you have a specified arbitrator provider, you want to look at what the rules are. What do I need to do? What do I need to give them in order to initiate the dispute and the arbitration? How am I going to make myself a claimant? Or it's also good to know, if you know that this is coming down the road, if I'm going to be a respondent, what do I have to do and what is my time frame? So I think those things are all going to shape what happens during the course of the proceeding, what the procedural flexibility will be one way or another. For example, the AAA has a whole set of rules for complex commercial, but a lot of those are kind of vague, and you can build out and try and make it your own arbitration in one way, shape, or form. Next slide.
All right, so now once the parties have agreed to arbitrate, the process officially begins when one side files what you call a demand for arbitration. The demand is usually filed with the arbitration provider. That's AAA, JAMS, WIPO. And you'd send that along with a copy of the arbitration clause from the contract. And of course, you have to pay the filing fee. So just think of the demand like a complaint in federal court. The demand should identify the parties, outline the key facts, describe the dispute, and it should specify what relief you're seeking. It also needs to include, again, the contract or agreement that gives the provider jurisdiction to handle the case. So each provider, it does have its own clerical and procedural requirements. So it's important to double check those details before filing. Could be limitations like word limits, how to serve the other side, and payment structure. So just double check those rules from each provider. And finally, it's definitely important to have your house in order. So that means making sure your contract, correspondence, and all evidence and documents supporting jurisdiction of your claims are organized from the start. Because a well-prepared, clear demand not only gets the arbitration moving faster, but it also sets the tone for the rest of the case.
And along that line, it's pretty easy to get to about 95% done, but to go from 95 to 100% done takes a lot of time. And really double check everything Spend a good amount of time on the relief that you request. Make sure you triple check, parties to the agreement, names, etc. You want to make sure you have the right party, right claims, right requests for relief. So in theory, it's relatively straightforward, but because you're the author of this, really make sure you've got everything set before you pull the trigger.
So I'll talk a little bit about arbitrator selection. There are many, many ways that you can decide how you are going to choose a panel. It can, again, be in your arbitration clause. It can be the way your provider recommends, and there are different ways, and I'll talk a little bit about those. In a situation where we're dealing with what I'll call hard IP, so the patent world, you really need to understand technical expertise. You need to understand what the arbitrators know or have had access to in their past, have a good sense of who they are and what their special talent might be that may be helpful for you as an advocate to actually be able to make them understand if there's a technology issue, what the technology is, and how to kind of best attack that when you're in front of a single arbitrator or a panel. Now, you might have a panel. You may have 3 judges. Those could be chosen in different ways. I've seen, we've had agreements where, we get to choose a panelist, the other side gets to choose a panelist, and those 2 choices now choose the presiding arbitrator in a panel. I've seen where we have 3, and you'll get, you'll get, 10 or 15 or 20 names from a provider. You'll go through those, you'll rank them. The other side will do the same and rank those. And if there's good overlap, then you have your panel, the first 3 that seem to be on everybody's list. And then they typically will select among themselves who the lead panels will be if you have a panel. You may have just the opposite. If you just have a single arbitrator, you may have 10 names, and it'll be the first one you both select. So, it's a way to get there. The thing in the end is these arbitrators are going to rule your case. They're going to make decisions about evidence. They're going to make decisions about what they want to hear, how much discovery they will allow. Will they allow interrogatories? All these different things. These are crucial things to think about, crucial things that they will often tell you in their little bios, very often video bios that you will see when you look on these on their websites and things like that. So.
And one thing we'll get to kind of in the good, bad, and ugly is one arbitrator versus a panel of 3. One certainly has the benefit of reduced cost, but I think 3 is much more comfortable in that even though you can study bios, you can do your homework, they can look great on paper, they might go a little bit rogue and behave quite differently than you expect. And I think having 3 to kind of balance out each other can be very valuable because, everyone is subject to their particular tendencies. And I think if you have a panel of 3, hopefully you'll get a more balanced resolution. But again, it comes with increased cost.
Yeah, and I'll say I've had experiences in both, and they both can be good and they both can be bad. Continue. Okay, so the preliminary hearing, what happens? Well, typically now the arbitrator or arbitrators have been selected. You're going to have your first sit down to discuss effectively how the case is going to go. What's the timing that's required? The parties really can dictate that. If they agree ahead of time, we want a case that's going to be very fast and done in 90 days, the arbitrators will typically allow that to happen. You will have to give in some way, shape, or form. In terms of limiting your discovery, limiting the number of depositions, limiting how much evidence can be presented at a hearing and how long the hearing will be. The arbitrator begins to understand you, you begin to understand the arbitrator or the panel, and you move forward from that. But this is where you're really shaping what will happen in the arbitration based upon what you have in your arbitration provision and the discussions and agreements that you have with the arbitrator. And most of these arbitrators have very strong feelings about not having too much discovery, And so if you're in a discovery-heavy case and both sides agree, you just have to make that known and kind of make sure they understand how the flow of documents will go and other evidence will be obtained. Next slide. Speaking of discovery, there we go. And we put discovery in quotes because it really, in many ways, is not discovery in the federal rule sense, or it can be. I think the typical tendency of an arbitrator is that less is more, that most of these disputes can be resolved without deep dives into everybody's emails and documents and 15 depositions, and that may be true. There are other disputes that really require very, very thorough analysis, biotech disputes, things like that, where you really need to get into documents and you really need to understand processes. So you need to have a decision first from the parties. Do they agree that discovery is necessary? If they do, how much? And you will listen to the predilections of the individual arbitrator or the panel to try to have an understanding of what that individual wants. Do they not want to have tons of documents exchanged? Do they not want interrogatories because they don't find them very valuable? And it creates more of a blog for them where they're getting constant complaints from the parties that somebody's not living up to their discovery. I think they want to avoid that and move as quickly as possible to the hearings. They will allow for document exchange. They will allow for depositions, and the parties probably can exchange admissions, but the enforceability is going to be an issue and a challenge as you move forward.
All right, so now let's talk about the hearing, post-hearing submissions, and the actual award. And before we get to that, one thing to take in mind is as you're going through the arbitration and leading up to the hearing, there may be a few little squabbles or mini disputes along the way. I think those who practice in district court typically experience a judge having a telephonic hearing. You might get 15 minutes, you might get 30 tops, but it's usually relatively brief. Something to be aware of, especially when scheduling and planning your day, is often these arbitrators do not have the scheduling constraints of a district court judge. So a hearing that you think would typically be 10 or 15 minutes might go for 2 or 3 hours. So that's something to think about. And if you want to make sure everything is pretty efficient, maybe consider having in that framework early on that, routine hearings may not exceed 30 minutes, etc. But again, there could be times where you want more time. So you may want to stick with the flexibility, but just be aware that, the practices are quite a bit different than district court. So for the hearing itself, it's basically, akin to a trial. That said, it's usually less formal and a bit more flexible than a district court trial. You want to get your witness testimony out, you want to cross-examine the other witnesses, and you want to get your evidence in. Think about early on, try to work with the other side, and then bring it to the arbitrator or panel. Are there going to be pre-hearing submissions? I think they're a good idea. They can really focus things, basically make you do your homework as well as the other side in advance so that everyone is ready to roll by the time you get to hearing. But think about page limits, issues, etc. Also think about whether there will be a hearing protocol, basically a guiding document to govern how the hearing will occur. Everything from evidence objections to documents. Are there going to be hard copies to the fact finders? Is everything going to be electronic? Pretty much anything you want to put in there, and the arbitrator or panel may have their own requirements that will go into that protocol. But really spend some time thinking about what ifs, and making sure that those are in the protocol so that while the hearing is going on, which is a relatively stressful time, there aren't any surprises. Think about how long it's going to take you to put on your case, and then how the time will be divided and how that will be measured. Depending upon the nature of your opponent, they might be really quite reasonable. Other opponents might have a stopwatch, with amazing accuracy down to the millisecond, and will fight over every millisecond. So take that into account. Also consider other logistics. Certainly since COVID, the concept of using people remote, via Teams or Zoom is much more common than it was. Do you want everybody in the room? Are you going to permit some people to be remote? You likely have experts going on. They're typically quite busy with other matters. Is there going to be flexibility if someone has a scheduling hiccup, how that will be handled? In terms of presenting the evidence, does the hearing room have AV capability, or do you have to get a private contractor to come in and bring in monitors and microphones and things like that? So don't take anything for granted. Work with the forum, be it JAMS or AAA or whatnot, to see what options they have available. And if those aren't suitable, you're going to have to basically get them on your own and work with the other side to get those in place. After the hearing, the arbitrator or the panel may ask the parties to submit post-hearing briefs or additional evidence to clarify the issues. I personally think this is something you should raise before the hearing, because you don't want to have gone through the whole hearing and then get blindsided by all these questions or issues or documents that the arbitrator or panel may want. So if you can at least get an idea of how they're heading before the hearing, that could impact how you present your case. And then once you've had the hearing, any post-hearing submissions go in, there will be some amount of time, and then the arbitrator or the panel will issue the award, which is basically the final decision.
Are you done?
Yes?
Because there is a question pending, so I want to try and address the question. And Erin, you can chime in too as you wish. So the question is, in which extent arbitration clause could prevent one of the parties to challenge a patent dispute in an IPR proceeding in the PTAB when an existence of an arbitration agreement between parties be used as a factor to deny a petition? I think the answer is that you will have a situation where it is likely today that if you had such a provision, that you would have a situation where the institution would be denied. And I say that today. I think it may be a little less clear earlier. I have a feeling that under the current administration and the current director, an excuse like that would be one. You've already agreed not to do this. How do you now turn around and say you're going to agree to do it? And then there's another question, which, or I don't know, Erin, did you want to add anything to that answer?
Nope, I agree.
Okay. And then another question is, could the hearing be held in person or remote, be recorded by the parties or an arbitrator? So the answer is yes. I mean, a lot of times there is, we've had stenographers, court reporters of one sort or another at, I think, almost all of the arbitrations that I've been at. I'm trying to think if I've had any. I think it's some smaller arbitrations that are kind of non-IP, more in the securities realm. I even think in those, there's usually a court reporter or a stenographer of some sort. So I think they are recorded in some way, whether it's video recorded. I would think that if somebody is on the screen, there may be a video recording, but in any event, the transcript will be taken.
And that transcript becomes very important, because if there are post-hearing submissions and you say the sky is blue, you need to put a cite to the hearing transcript wherein Phil testified, or meteorologist Ikenna testified that the sky is blue. So that written record often is very important for the post-hearing submissions. All right, and turning now to slide 22, yes, the FAA allows an appeal of a final decision, but the grounds are really limited. If the decision maker has made a mathematical error, some sort of error related to form, if there's been fraud or corruption, or they've exceeded their authority. But basically, overall, that's really quite narrow. You can't simply appeal because you don't like the decision. So keep that in mind. And again, I personally think that's an aspect that favors going with 3 arbitrators as opposed to 1, in hopes of getting everything right. But that's personal decision. And then, of course, an order dismissing claims in favor of arbitration is immediately appealable.
Right. So we've established the framework of IP arbitration. So now let's pull back the curtain and talk about the good, the bad, and the ugly. So starting with the good, one of the biggest advantages of arbitration is confidentiality. So unlike court litigation, arbitration happens behind closed doors. So even filings, testimony, and evidence, they aren't made public. So that's critical in IP disputes where you're often dealing with sensitive business information, such as trade secrets, source code, or licensing terms that you don't want your competitors getting a hold of. So this is especially valuable in patent licensing, technology transfer cases, where the details of the technology itself is at the center of the dispute. Another benefit is expertise. So in arbitration, you get to choose your decision makers, which means you can pick arbitrators with technical or IP backgrounds, maybe even a former patent attorney like ourselves here, a patent examiner, or an engineer. So that's a huge contrast to litigation, where you could be explaining more complex technology to a lay jury or judge who is lacking IP experience. So having an arbitrator who understands the technology leads to faster, better informed decisions and fewer misunderstandings in your case. And of course, you have efficiency and flexibility. So arbitration is designed to move quickly under some of the rules from institutions like the AAA, GEMS, or WIPO. The procedures are streamlined. So you typically see fewer motions, limited discovery, and more flexible scheduling in arbitrations. And most IB arbitrators can wrap up cases in about 12 to 18 months compared to 3-4 years that you'd spend in federal court in some cases. So that kind of speed absolutely can make a real difference when you launch a product or a partnership or licensing or sort of the matters that you deal with in IP. All right, more of the good. You have neutrality and enforceability. Another big advantage, of course, is neutrality. That's when your dispute involves parties from different countries or jurisdictions. Arbitration provides a neutral forum where neither side feels like they have home court advantage. So this is just as important as flex enforceability. Under the New York Convention of 1958, arbitral awards are recognized and enforceable in more than 170 countries. So that's a major reason why international IP licensing agreements often choose arbitration, because you have the ability to enforce the award across borders far more easily than a court judgment. And then you also have finality. Arbitration awards are binding and enforceable under the FAA, and courts have very limited power to review them. So typically, once an award is issued as res judicata, that's legalese, basically means that between the same parties and the issues can't be really relitigated in the same dispute. So again, that's valuable in the IP context, where it involves ownership, licensing rights, or royalty obligations, where closure and predictability are critical for your business continuity. All right, and
I didn't unmute myself this time. The next 2 slides really, this slide really gets back to really the same point that Ikenna just made, that they are, an award is final and it is predictable because you are getting it from a forum that you basically paid for in some way, shape, or form. So you know what you should be getting, especially if you've done your work up front. We're all disappointed at times with decisions of arbitration panels, just as we are with juries and district courts, but those things can happen. My experience is that the arbitrators or whether it's a panel or an individual, try to get it right. And that's supremely important in all this. Go to the next slide. But if you do, but before we go to the next slide, poll number 2 is up for credit. Do you need credit? If you do, say yes. Yeah, it doesn't let me do it. Hosts and panelists are not allowed to hit the little button. Okay, so we move on to, did we go to the next slide? No. There we go. The good. Limited judicial review. I do view this as a good. I think that's the point of arbitration. The point of arbitration is to get that sense of finality. What are the bases for vacating an arbitral award in the federal courts? Corruption, fraud, or undue means. Okay, that's all understandable. Partiality or corruption in the arbitrators. We get that. Guilty of misconduct. We get that, the likelihood of 1, 2, or 3 happening is almost non-existent in the types of disputes that we're handling, because we're having enough time with these individuals. Is it possible? It's always possible. The fourth one is the one where we really see where judicial review happens. Usually it's denied, but it's where the arbitrators exceed their powers. So if there's a question about the scope, if the scope determination at the beginning of the arbitration is incorrect by the arbitrator, what they view as being within their purview, it may be that the award or part of the award will need to be circumscribed. Doesn't happen very often. So, but that's the area where there is likely to be some sort of dispute that goes to the federal and the state courts.
All right, turning to slide 26. Arbitration deals with some really hardy disputes and some awards. So in 2024, over 1.2 billion in total claims were filed in technology arbitrations before the AAA. The average claim was 2.38 million, and the largest claim was over 319 million. So these are big disputes that are going on before these arbitration entities. Counterclaims also were quite high. They totaled 391 million, with the largest one being valued at 125 million. As an example of some entities you're aware of, Samsung was found liable for 134 million in royalty payments to InterDigital in an arbitration that occurred over a patent license agreement. So if you were thinking arbitration is only used for small disputes or small amounts in controversy, that's not the case. They can and do get involved in really big cases. Turning to slide 28, another one of the things that we put under the good category is basically how quickly these arbitrations can move. So if you think in the US, general district court case is about 2.5 years. That's that purple bar to the upper right. Before the AAA, in the smaller cases, one under $100,000, they went as quickly as just over a month, but the average is about 7 months. Similarly, for cases that are about 100 grand up to just under $1 million, again, it can happen really fast, just over a month, which I find amazing. But the median was about 10 months. And then again, if you get into those bigger disputes over $1 million, the quickest was about 6 months, and the median is about 1.5 years. So even that 1.5 years is still quite quicker than district court, which generally is 2 to 4 years. So if you want to get this dispute wrapped up quickly with finality, arbitration could be a good forum for you.
And let me just add, I think that what's interesting about this is one where, in some ways you're in advance writing this arbitration clause, so you've already decided to be in arbitration. But if you, in a situation where you don't have an arbitration clause, these statistics actually are meaningful because they say you can be done with your dispute in a relatively short amount of time compared to a trial in the district court. You won't have the bases for appeal. You won't have a way to perfect things in the same way but you will have some opportunity, if you agree with the other side that this is better to go into an arbitration forum, to truncate the amount of time that you want to be, that you will be involved in your proceeding. That having been said, I've been in cases where the arbitration went on 6 years with a 9-month trial. I've been, a 9-month hearing. I've been in cases that are a year with a 3-month hearing, and then some with 3-week hearings, and some with a week or just a couple of days. It really depends upon the dispute, and it depends on whether you can get all the parties together relatively quickly in the scope of discovery.
All right. So just like everything else in life, arbitration is not perfect. So there are some trade-offs and limitations, especially in the IP context. These will include areas where arbitration are less advantageous than litigation. One example is limited discovery. So one of the main complaints about arbitration is that discovery is much narrower than you'd get in federal court. So there's no right to full discovery or broad subpoenas beyond what the arbitral rules will allow. So third-party evidence can be hard to compel in a lot of cases in arbitration. So that can be a challenge in IP cases where you might need technical documents or source code from a non-party or maybe a manufacturer that's also a non-party. Now, on the flip side, the limited discovery helps control costs and it keeps the process moving. But again, it means you need to prepare early and target what's truly essential in your case. Another example is restricted appeal rights. So under the FAA Section 10, courts can vacate an arbitral award. And I think Erin touched on this, but it's only very narrow grounds, things like fraud, corruption, or arbitrators exceeding their authority, which rarely happens. But really, there's no general appeal just because a party thinks the arbitrator made a mistake on the facts or the law. So what you get in arbitration is finality, but you give up the safety net of appellate review that's more available in federal courts. Now, it's more of the bad things or limitations in IP arbitration. That's cost uncertainty. So while arbitration is often marketed as cheaper, that's not always true, especially when you're dealing with complex IP cases and technology. Arbitrators and institutional fees can add up. And that's particularly the case when you have 3-member panels or you need qualified technical experts to come into the case. Those fees can accumulate. So the key to manage your costs is, good scope management. Just keep the process lean and avoid unnecessary procedural sprawl. There's also limited precedential value in arbitration cases because there's a lack of precedent. Again, that's because arbitration awards are confidential, so they don't create binding guidance or precedent for future disputes. So that can just make it a little harder to predict some of the outcomes across similar IP issues, unlike published court decisions in federal court.
I do want to add, oh, sorry, go ahead.
Go ahead. Okay, sure, yeah. And I'll just wrap up here with public policy limitations. So public policy plays an important role in defining the limits of what can be arbitrated. So under 35 U.S.C. Section 294A, patent validity and infringement can be arbitrated, but that's only between the parties. So the award doesn't bind the USPTO or the public. It only binds the parties. So even if an arbitrator finds a patent to be invalid, it can still be valid in the public record until the Patent Trial and Appeal Board, the PTAB, cancels it. So it's just an important distinction to know between private resolution and public rights that do arise when you have these complex IP cases in arbitration.
And I just wanted to add, on the prior slide, we talked about limited discovery. One of the things that we didn't really touch on is the ability of the federal courts and other courts to actually require witnesses to appear and documents to be provided for use at the hearing. So there's a difference in the way arbitration powers are given to the arbitrator by the Federal Arbitration Act. The arbitrator doesn't have the power to compel discovery. It can suggest it. It can request it. But what it can do is it can compel testimony either in the district or wherever it happens to be, or by other means, can be by Zoom, by video in some way, from another district during the course of the hearing. Now, some smart lawyers have gotten together and said, well, arbitrator, let's have a special hearing where we bring in that evidence that way. And so, it's a bad, but it's one that can be worked around, and there are judicial processes, but it gives you if you're sitting there and you always want to know what the answer is going to be before it goes in front of the arbitrator, that may not be possible. You may have to really play it by ear, hope that you've got a witness who's going to be helpful for you, and ask your questions and see what happens. And hopefully you don't look like a deer in the headlights after.
And staying on cost uncertainty, that is something to really keep in mind. Costs can go up quite a bit. And generally, folks view AAA as the most economical, followed by JAMS, followed by the ICC. So keep that in mind when selecting your provider. But there are moments when those invoices come in for the hearings and whatnot where you think, goodness, this is much more expensive than district court. So again, it can be great, but don't underestimate that cost angle.
Okay, we've got a limited time. Go. Next slide. We're talking about the ugly. The ugly is, and we've talked about this to some extent. In arbitration, panel discretion or arbitrator discretion is huge. And so you really have to kind of look at things and understand that there is a strong possibility of unpredictability in what the result will be. You do everything you can in your power to streamline a case to get it to be where you want it to be. Doesn't necessarily mean you're going to win, but you want to have it within the kind of the bounds that you expect it to be. And you're rarely going to get that overturned in any way, shape, or form. I think we all know about split the baby outcomes. Everybody knows that, the idea is arbitrators will, I'll give you a little and I'll take a little, I'll listen to everything. And that's always troubling. Because you always have that possibility. I can tell you that in most of the arbitrations I've been in, and it's been a one way or the other, and I could justify the results even when they were against me, which they rarely are. Enforcement complications, there could be some of these, under FAA, not a problem in the United States. Some jurisdictions are more difficult in international enforcement issues if there are public policy questions involved. Does it happen all that often? I don't know. Go to the next slide. You don't have transparency. You have confidentiality. That is a good and a bad thing. Where it mostly hurts you is not knowing what the arbitrators have done in the past and how they have executed in their cases. And you have to do a lot of research where you talk to people who've been before an arbitrator or an arbitration panel. So you get a sense of what you think you're going to get at the end. How experienced, how did they run the hearing? What were they looking for? Were they purely fact? Were they law? Were they fact and law and good at both? And that's where you really want to be. There is a loss of leverage. You don't have the ability to go to do a lot of juries, motion practice, things like that. Erin, what are you going to say in the last slide?
I'm going to try and quickly answer the chat question, which was about how much have you seen for AAA fees? I believe I've seen over 300 grand, maybe as much as $500,000. Like higher. It was even higher. It really got high. So just be aware of that. In terms of key takeaways for arbitrations in the U.S., it's a powerful tool. It's confidential, efficient, expert-driven. Can be especially helpful for licensing, royalty, and contract-based IP disputes. You might end up hopefully with an arbitrator or panel that have really strong technical and or legal backgrounds, and overall it's a lot faster than federal court. But again, keep in mind both the bad and the ugly aspects that we talked about today before deciding if this is something you want to do. And if you do, think about it at the drafting stage as opposed to simply the enforcement stage. So thank you for tuning in today. Please be sure to do the survey at the once we conclude here, and we look forward to seeing you at another Panitch Training Academy.
And feel free to write. We will answer questions offline.